Welcome back to Bracewell's monthly environmental webinar for in-house counsel. As usual, we've selected a topic that's probably not front and center for you, but lurks on the periphery of your vision as something you probably are worrying about or think you need to worry about and haven't had time to dig into or get an update on. In this case, we're going to focus on the legal risks that arise when companies set targets for reducing their carbon or greenhouse gas footprint. I'm Kevin Ewing, a partner in the Washington office of Bracewell, and joining me today is my partner, Seth DuCharme. Seth sits in our New York office, and he chairs the firm's nationwide government enforcement and investigations practice. He's a career prosecutor from New York City and in Washington, D.C. Seth served, in fact, in the Justice Department at the highest levels, indeed as the highest-ranking career prosecutor in the Justice Department. So we're very fortunate to have his perspective as a former prosecutor and current defense lawyer on how carbon targets intersect the civil and criminal liability codes that we have in the United States. So welcome, Seth.
Thank you very much, Kevin. It's really a pleasure to be able to talk to you today about this very important topic. And when you said things in the periphery of our vision, I think the point of this conversation is that sometimes it's the things in the periphery of our vision that poke us in the eye. And while I don't want to exaggerate the risk to our clients about the potential regulatory actions that can arise in this space, it is critically important to have an awareness because the consequences can be substantial for companies that are ignoring the risks.
Good point. And I think that's a great jumping off point for us as well. So let me give you the bottom line up front here quickly, and we're going to dig into each of these points. You will not be surprised to know that ever more publicly traded companies are setting these targets for reducing their gas emissions, greenhouse gas emissions. They can be methane emission targets, they can be broader greenhouse gas emissions targets, and they can come in a variety of flavors. They can come as intensity targets or absolute amounts or reduction amounts off of a base year in the past. Lots of different formats, but targets that they publicly commit to. And that trend is rising and has already achieved a significant penetration. We'll look at the numbers there. Committing to these kinds of targets and integrating them into companies comes with some legal risks. And the liability regimes are tightening in the U.S. around these kinds of legal risks, not just in the U.S., by the way, but also in UK, Europe. We'll save the UK, Europe for another webinar, but just to foreshadow that it is not just a U.S. phenomenon by any stretch. And there are also mitigation measures that are possible that companies are exploring or indeed using to address the legal risks that attend the commitments that they're making. So it's all part of a package of understanding where risk comes from and how it arises in the context of carbon targets. So let's dive in. I said I'd give you a couple stats right at the outset. Let your eyes kind of pour over this for a moment. You'll see that obviously there's a lot of penetration in public companies globally. These are global numbers, except where indicated. We have more than 50%, indeed almost 60% of public companies reporting Scope 1 and Scope 2 greenhouse gas emissions. Now, scope reporting is not quite the same thing as target setting, but we have seen that those who begin to report year after year Scope 1 and 2 greenhouse gas emissions tend also then to be contemplating or in fact acting on pressure to set targets as well. And indeed, we see that with a number of 52%, which is trailing the 60%, but not by much, have set, in fact, emission reduction targets by now. And 38% of those companies have set net zero targets, typically fairly far out into the future, think 2045, 2050, but nevertheless, a very specific kind of target. And a perhaps surprising percentage in terms of its size, the largeness of the number, 20% of a couple of companies have set what are called science-based targets. That is to say, targets that the company believes would help it, if everyone else did the same, align to keeping global temperature rise to 1.5% degrees Celsius. So what these statistics show is simply the fact that companies are embracing and pursuing carbon target commitments. They're doing that publicly, and it's part of life and the future ahead. When we look at the drivers for this, there are several. First, of course, there are the ratings agencies. Publicly traded companies live and die sometimes by the ratings that they have, or at least they think they do. And advisory companies, that is to say shareholder advisory companies, have a big impact as well on how votes, for example, shareholder votes take place and what kinds of issues, including climate-related policies, are going to be adopted by a company or not. So ratings companies and advisory companies have been exerting increasing pressure on certain public company sectors to set and commit to targets. And shareholders directly have been doing that as well, particularly institutional investors that have a lot of clout because of the capital that they hold. Lenders have been doing that. We see that both globally and in regional policies. Regional, for example, particularly in Europe or Europe-based international lenders are using fossil investment policies and sustainable investment policies to alter the mix of lending and credit that they do in different sectors. And as part of that, many are requiring or favoring in their commercial terms those companies that have set targets. And we mustn't overlook the supply chain either, the commercial side, where companies who are suppliers to you have their own reporting responsibilities, or in particular, where you are in the supply chain of another company, and that company has reporting commitments that it has made, it's going to downstream that to its supply chain and say, give me the information from your company so that we can feed that information in our upstream reporting or downstream reporting on the supply chain. So we see lots of different kinds of drivers for the setting of targets. But while we could go deep here, it's more interesting to talk about how legal risks can arise, because that's where Seth is going to spend most of his time, and we're going to engage in this discussion today. The principal takeaway is that from our study of this over many years, and we've been looking at these risks for more than 25 years. So we've seen the arc of development, and the simplest statement that we can come up with, sort of wrestle it to the page, is the risks arising from a material divergence between what the company does and what the company has said it would do, or more specifically, what the company caused the public or the marketplace to believe it would do. Now, sometimes the market or the public infers things about company statements that were not intended. But what matters is what the public or the market thinks, not just what the company intended. And so that divergence between what the company does and what the market expected, that's the stress. That's expectation versus reality. And it is in that gap between expectation, market expectation, and corporate reality where legal risk grows. So let's spend a moment talking about what kind of examples reflect the divergence between expectation and reality that we think really drives the legal risk here. There's some obvious examples, there's some less obvious ones. Let your eyes wander over this page. I'll pick out a few. Certainly the more obvious ones are setting targets where the company does not have the means to accomplish the target, or setting a target where you might be able to do it, but you don't have the will or the decision-making or the leadership to actually make the attempt to achieve the target. That's a target, obviously, that's a Potemkin target. It's a false target. It's an illusionary one. And that sets up a market expectation that's not going to be achieved. And it's fairly obvious that that would generate a potential for legal liability. And Seth will talk a little bit about the statutes that would go in that direction. But there's some less obvious examples of divergence as well that we have to keep our eye on. And that's setting targets, for example, that are in some sense too low or even achieved, because the setting of a target by itself suggests that it is a goal not yet achieved. The target is supposed to suggest an improvement over current performance. But if that target, in fact, is one that's already achieved or essentially achieved, then the promise of improvement, which is implicit in the setting of a target, is actually belied by the actual target that's been set. And that creates that divergence between expectation and future reality of corporate performance. I'll pick the last one as well as an example, publicly reporting scenario analysis, which is used so often in climate-related assessments and risk assessments. Often companies will run multiple scenario analyses on different factual bases or inputs, assumptions. But where they report all of them, but they only use, for example, one of those types of analyses in its decision-making, the company needs to be very careful about the suggestion to the marketplace that it looks at all of these analyses and uses them all in its decision-making, while secretly, so to speak, actually using only one and discarding the others. This is By the way, all of these examples of risk and divergence are already in existence. We have experienced and watched this ourselves. These are not hypothetical examples. And so the fundamental idea about divergence is that the market is perceiving or setting an expectation based on an inference about your setting of a target, and that expectation is not actually met by the performance or even the intention and capability of the company to achieve. So when we think about divergence as driving legal liability risk, we should remember, before we dive into all the statutes involved, or some of them at least, we should remember a couple of things. One is that currently U.S. law does not actually require a company to set carbon targets. So every carbon target in the U.S. is set, at least within the U.S., voluntarily. And by the way, that's not likely to change in our view in the near term. The idea of new legislation that would require targets, quite unlikely. Similarly, the SEC disclosure rule, which is being challenged in the Eighth Circuit, whichever way that falls out, it does not seem likely that we're going to see a regulatory impetus for requiring carbon targets. Even the SEC disclosure rule did not require target setting. Having said all that, the takeaway, though, is not, oh, it's voluntary, so it doesn't matter. And Seth, I know this is an important point in your work. Whatever the corporate conduct is, whether it's voluntary or mandatory, it's corporate conduct, and that conduct can lead to legal responsibility. And so it is relevant, even in a voluntary context, to understand what regulators care about and what kinds of liabilities can arise under what statutes. So what do the regulators care about? There's a difference in their minds between material misstatements of facts, being misleading, omitting material information on the one hand, and commercial puffery, where you gild the lily a little bit about just how good your product or service might be. The distinction between aspirational puffery and material misstatement, of course, is a bit in the eye of the beholder. And there's not a hard and fast line, but there is generally an effort by the regulators and the Justice Department to make a distinction between what's really important in the marketplace and what's not. Now, that having been said, let's put some examples out there. The Vale example, this was an SEC action in 2023 for misleading investors about safety in the company's assets. They have dams in South America, and those statements about how safe their dams were and their capability of delivering safety from their asset base were overstated, as became clear later, actually very soon thereafter, when there was a very deadly dam collapse. And so the SEC went in and said, now, wait a minute, we've had this terrible disaster. What were you saying about safety in the prior years? And they looked and said there was a lot of statements about safety that were overstated, as it turned out. Was that puffery, or was that a material misstatement? Well, they came to the conclusion that was a material misstatement, and that led to a very serious action against the company. In Bank of New York Mellon, this was the investment advisory services of Bank of New York Mellon in 2022. And the focus there was on misstatements and omissions when applying ESG, sort of sustainability criteria, when making investment decisions. Basically, the idea that the SEC pursued was you, in a particular advised fund, were implying and raising the expectation that you would apply green investment criteria to a much greater extent than you actually did in your decision-making. So the divergence was between decision-making in the real world and what you committed to in the public. They didn't resemble one another sufficiently. And so there was an action brought. Simbritsky, 2020. So you see, these started several years ago, and Simbritsky isn't even the most recent. This had to do with the misleading statements about the viability of their product, how good their product was, in this case, desalinization processes to remove salt from salt water. A very significant product for the company, and therefore the significance of the misstatements or the misleading statements was viewed as material and not just commercial puffery. So these actions are mere examples. There are many others, but it sets the table, I think, Seth, for you to take us forward in a discussion of the sources of liability in the U.S. and what drives the liability options and approaches taken. So, Seth?
Kevin, thanks very much for that very helpful setup and the examples that you used. I think what's critically important for our listeners to understand is that there is often a difference of opinion between the government enforcement and regulatory agencies as to what constitutes misleading statements. I'm going to use that as the general term. The government interest is that the public and investors not be misled by the statements of a company. That's how they identify their equity. They have statutes, which are the weapons that they wield enthusiastically. And in preparing to meet the expectations of the government, which is really how I identify the challenge for clients, our clients often think, and companies often think, we need to meet the expectations of our investors. We need to communicate with the public in a way that's effective and also projects, naturally, confidence and value in the work that the company does. And there often is a gap in the conversations that we have with the government enforcement regulatory agencies as to what their expectations are there. So you've given some very helpful examples, but I really want to try to bridge this gap because I think empathy is the secret sauce to this. There should be no surprises to a company. From my point of view, no company should ever be surprised to learn that they have violated a federal statute, but sometimes they are. And that's where the problems come in. So the weapons that the government wields in this area of ensuring integrity to the markets and to preventing misleading statements from being made, to deter both generally and specifically those statements from being made. The civil statutes that apply, the tools used by the Securities and Exchange Commission are sections 10B, 13A, and section 17A of the Securities Act. We'll talk about those in a little bit of detail in a moment. And then criminally, the statutes that most typically come into play are the wire fraud statute, which can relate, also to securities fraud. And mail fraud seems almost to be a bit archaic at this point, but mail is still occasionally used. Wires are used inevitably in doing business. So why do we talk about these things in parallel? It's because the government approaches these scenarios in parallel. Companies are often facing parallel investigations by the Justice Department and the SEC relating to the same conduct. And while the thing that they have in common is their focus on misleading statements or material omissions, there are important distinctions in terms of the burdens and the penalties and the way that a company can effectively defend itself from an allegation or an accusation or an investigation into the conduct. 10B, which is the primary tool of the SEC, makes it unlawful for a person directly, indirectly to, in connection with the sale or purchase of security, engage in essentially a manipulative or deceptive scheme to defraud. That's in essence what the statute says. So they're looking for patterns of conduct. There must be a security, of course. In some industries, whether or not a particular instrument is a security can be hotly litigated, but assuming the existence of a security, and the SEC often can and does to establish jurisdiction, what they're looking for is patterns of conduct, schemes to defraud, series of communications to the public or investors, which establish a state of mind, with what we call scienter, so some intentional conduct. Section 13 relates to the reporting requirements that are generally applicable to persons, including corporate persons, corporate entities that exercise investment discretion. And so every issue of a security that's registered pursuant to the Act has these reporting requirements, and Section 13 focuses on those reporting requirements. And Kevin alluded to the extra burdens that are imposed on companies that have such reporting requirements. Section 17 is important to distinguish from 10B because it often focuses on the exact same conduct, but rather than having a scienter requirement or an intentional state of mind, there can be liability under Section 17 for a negligent state of mind. So a lower mens rea for the government to need to establish in the pattern of communication. So when the SEC brings an action or it's investigating conduct with an action in mind, it typically is going to be looking at 10B and Section 17 at the same time and often brings those claims together. And often there's a debate between the company and the SEC whether or not first there was any negligence at all, any misleading statement, but then even assuming that there was, what the state of mind of the person or the corporation was in making that statement. There can be, greater reputational consequences, certainly for a finding of a 10B violation, because that's a more serious, I think, from my point of view, claim for the SEC to bring. But ideally, companies want to have confidence that they are exercising, with respect to a negligence claim, the reasonable standard of care in how they review the communications that are made to the public or investors. That is the very baseline expectation from the SEC. And what a reasonable standard of care is, as any legal term of art, can be subject to discussion. And so coming back to some of the things that you said, Kevin, when a company is making an aspirational statement or an optimistic statement, or what we might, in defending the company, call mere puffery, which the courts have acknowledged is not actionable, the company needs to have real confidence that it is internally, through its compliance and legal departments, vetting any of the statements that pass outside of that company that can reach the public, that can reach investors or counterparties. And they're scrutinizing those statements. And they have a process in place that gives the company confidence and ultimately should give the government confidence that the company is meeting or exceeding what would be a reasonable standard of care in vetting those communications to make sure that they are accurate and not misleading, and that they are complete and do not omit facts that the government would expect the public or investors, objectively speaking, to take into consideration when making an investment decision with respect to the purchase or sale of securities. So just to sort of sum up on the SEC statutes, the bottom line, and I'm sure most of our listeners are saying, of course, I would never be misleading. That's an absurd suggestion. Of course, we're truthful in our communications. And we project confidence in what we're doing. We do communicate with the public and investors and our counterparties. We feel very positive about the direction of our company, how we're creating value, and particularly within the space that we're talking about here, where there are evolving technologies and there are particular requirements and targets and goals that, of course, we're not going to be misleading. The government is highly scrutinizing these statements. I cannot emphasize this enough. The current SEC and DOJ, which I'll talk about a little bit more in a second, they are scrutinizing these statements. And Kevin, when I was in the government, it was a compliment to a prosecutor to say, oh, that prosecutor is very aggressive. They take that as a compliment. Now that I'm on this side, I think what we all hope and expect is for a very reasonable prosecutor. And aggressive, can have different meanings to different people. But the government, the SEC and the DOJ, has taken an unequivocally aggressive posture. They're scrutinizing the statements, and they have very high expectations of companies that there will be vetting of any communication that passes outside the company. And when I say any, I really do mean that. We use social media to communicate now. That is how the world communicates. So the formality of the communication is less important than it once was. Any communication that passes outside the company that goes to the market, the public, or an investor must withstand scrutiny from the government. And it's high scrutiny. So turning to the criminal statutes, the DOJ, when they're on a panel with the SEC, often will sort of smile broadly and say, the SEC has to consider its body of case law as it relates to securities. We don't have that problem. We have the wire fraud statute. And the wire fraud statute is quite broad. The wire fraud and the parallel mail fraud statute, which essentially one relates to communications, by wire, which is everything, emails, tweets, social media communications. The mail fraud and wire fraud statute address this notion of a scheme to defraud, again, fraudulent, misleading conduct using instrumentalities of interstate commerce. That's what federalizes essentially all of these claims. And so the mail is an instrument of interstate commerce, and wire communications that pass through interstate or international commerce are instrumentalities by which we all, of course, communicate. So what the Justice Department has is a broader statute, higher burdens of proof, also higher potential penalties. But the Justice Department has statutes that essentially make it a crime to use these instrumentalities of communications across state lines in connection with a scheme to defraud. So the commonality there is, are there efforts by the company to mislead, overstate, omit information in its communications to investors, to the public, to counterparties that overstate its position, exaggerate, or outright lie about the work that it's doing to meet these targets? So what does this mean for companies? Well, in defending, or more ideally, preparing to conduct business in a way that will never draw significant attention from the government, it's investing in thinking about, on the front end, doing the work to ensure that the processes internally that vet these communications are sufficient to withstand scrutiny from the government, so that any company that receives a subpoena from the Justice Department or from the SEC should feel confident that it can withstand that scrutiny. Some of the key differences, again, going back to these two statutory regimes, which are complementary of one another, and in having to satisfy potentially two regulators or agencies at the same time. The SEC has a lower burden of proof because it's potentially a civil enforcement action. So they must only establish facts by a preponderance of the evidence. On the other hand, they have a unique body of case law relating to securities or potential securities violations, and a body of case law that recognizes in the securities context certain potential defenses. The Justice Department must prove its charges beyond a reasonable doubt, but during investigations that can last years or more through parallel investigations, the company will always be confronted with how it can be comfortable in establishing for these regulatory agencies that the facts viewed by both the company and the department and the SEC come nowhere close to meeting the burden of proof, either on a preponderance or beyond a reasonable doubt standard, while there are discussions about what inferences should be drawn from the internal communications of the company about what it was trying to accomplish and the objectively reasonable interpretations of the communications outside of the company. Penalties are different. SEC typically will seek injunctive relief to stop ongoing offensive conduct. They may seek disgorgement of profits or gains to the company, and then they will seek civil penalties. And typically, if you ask the SEC what penalty are they looking for, they'll say something like a penalty that will be meaningful. And that can relate to both the size of the company and the size of the fraud as the SEC understands it. But meaningful means painful, frankly. The SEC, like the Justice Department, is in the general deterrence and specific deterrence business. So when you contemplate what the costs to a company could be in having to, for example, acknowledge a violation of 10B or Section 17A, there is the reputational injury that comes from that. There is the financial pain that comes from disgorgement or the payment of a penalty. There is the interruption in business that comes from an injunction. So these are all very significant penalties on the SEC side, which I think, frankly, justify the close attention to compliance and to maintaining an awareness. And that's frankly the point of our conversation today, I think, Kevin, an awareness as to what the government is focused on. The penalties from the Justice Department, and that will typically involve a main justice component and also often a U.S. Attorney's Office, those can be quite severe, up to and including extinction of the company and arrest and prosecution of individuals. It is the policy of both the Department of Justice and the SEC to look for both corporate and individual acceptance of responsibility or consequences. That's usually senior executives in a company. And while the Justice Department is not typically looking to extinguish companies, they want to extract a penalty, sometimes impose a monitor. They want the company to acknowledge wrongdoing. But if they see a way forward for the company to keep doing business, they'll look for, the payment of a fine, perhaps a deferred prosecution agreement, sometimes the imposition of a monitor, things that can be very, very prejudicial and consequential, all the way up to the arrest and prosecution of individuals in the most severe circumstances. So those are significant consequences. And I should say that just even absent any aggressive action at the end of an investigation by the government, long-term parallel investigations by the SEC and the DOJ, for which they have a great appetite, can be very expensive for companies in terms of the legal costs associated with even cooperating with those investigations, responding to subpoenas, communicating with the government, marshaling information that may not be available at its fingertips to ensure the government that the company has not violated U.S. law. That can be expensive. There can be a black cloud that follows the company for a long time. So the goal is this. The goal is do the work on the front end, make the investment in compliance, communicate internally with all of the decision makers and employees of the company that the company is committed to meeting the expectations of the department and the SEC, that the company is a good corporate citizen, that the company is thoughtful about its communications. And then the company will be in a good position where even if the government gets a whiff that something may have gone wrong, the company can say with confidence and with clarity and with factual support that the company has met and exceeded the expectations of the regulatory and enforcement agencies. So I'm happy to unpack any of that, Kevin, if you think it's helpful. But I think as just a table setting, it's really important for companies to pay attention to what's happening with SEC and DOJ enforcement actions, to take it seriously, to make the investments and to have confidence that if the phone ever rings or the subpoena comes in, that the company can withstand that scrutiny.
Thank you, Seth. I think it's very important to understand all of that landscape, legal risk and where it comes from and how it intersects with carbon commitments. Because carbon and greenhouse gas corporate policy sort of arose from the environmental side of the house, as it were, years ago, it can sometimes not be understood just how market significant those commitments are, and therefore what kind of attendant legal risks there are. So it's good to reset the table as you have done. And as you foreshadowed, turning now to mitigation, a couple of thoughts before closing. If I were to summarize the mitigation concepts in one word, it would be discipline, corporate discipline. When Seth was talking about a process for vetting, being able to factually document that there's a real systematic effort by the company to control how it communicates with the market, what it says, and how it says it and where it says it. That's all about discipline. And the mitigation that we see here can fall comfortably into 4 buckets, just to get the conceptual framework out. One is right at the outset. If you're setting targets, set sound targets. And what does that mean? What's a sound target? Well, a sound target would reflect at least 2 elements: achievable improvement based on reliable methods. That's sort of our digestion, if you will, synopsis of a lot of time spent over the years working with companies around setting targets. Achievability is important, that it be an improvement and not just an easily achieved target or already achieved target. And that the target is based on, and the achievement of it is based on methods that are reliable. That is to say, if you measure it this way, you can measure it again and again this way. It'll always give you the same number. That's reliability. A reliable pathway, a process that will take you from where you are now toward at least close to where the target goal is in year X. That's reliability of method, process. The second bucket really is to integrate that target and your commitment to the target in your decision making. It's just crucial to understand, first, that the target itself is not the commitment. The target is a number, or is often reflected as a number, but the commitment is your relationship between the company and its decision-making on the one hand, and the achievement of that target. The commitment establishes the degree of priority. It establishes how that commitment is going to be integrated in your decision-making. Is it going to be a consideration? Is it going to be a super priority? Is it going to be a factor in a balancing analysis? Which decisions are going to include consideration of the commitment and the target? So stating the target is part of it, but integrating the target through a clearly announced commitment to the target and how you intend to roll it into your organization is crucial. Governance, of course, takes many forms. In some sense, that's merely a fancy word for discipline, but you can boil it down to basically 3 things. Do you have the right people involved? And are their relationships to one another, the lines of responsibility, clear when it comes to both setting the target and implementing or integrating that target and the related commitment in your corporate decision-making? It's easy, if you will, for a company to develop within the EHS or maybe even the shareholder and IR, investor relations, from one of those quadrants of the company to develop a preference for a particular carbon-related commitment. But they aren't the only ones who need to live with that target and related commitment. So are all the other operational, commercial, HR, EHS, are at the CFO's office, are they all at the table? Consistently documenting is the second piece of it. As Seth said, when you sit down across from the regulator or the enforcement official, you need to be able to say, not just this is how we did it, this is how we tried to do it right, but here's the basis for our statement. Here's the documentary evidence that supports that this is how we did it and how we tried to do it and why we thought it would work and be sufficient. And then finally, you have protocols, but do you follow them? It is a terrible sign to the Justice Department and the SEC if you have the apparatus of governance through policies and protocols and procedures, but you don't follow them.
Did you live your policy is the question that they always ask, Kevin. But that rings very true with my experience. Did you live your policy?
Exactly. And so one of the things we're always careful about is the creation of excess protocols that then lie on the shelf. That's actually worse than doing nothing in that regard. And then finally, when it comes to transparency, remember the fundamental zone of risk is that gap between what the market thought you were going to do and achieve and what you actually were trying to achieve and what you did achieve. It's that delta area, that gap where risk resides. So one way to mitigate that is to be very consistent in how you speak to the market and very consistent and clear about what your commitment to that target actually is and what it isn't. If you are clear and consistent in explaining your target and explaining what the depth of commitment is or how you intend to live by that target or live toward that target, then there's much less opportunity for a significant or material divergence to arise between the market's expectations and your own performance. And at the end of the day, one last point here before we break. Setting a target is not the end of the discussion with the market. It really is the beginning of a journey. It's a long one. It does not have an end point. And it has to be treated as such. It has to be treated as a market dynamic commitment. So corporate nimbleness matters. Why don't we wind up here, Seth? Thanks again for joining us. We appreciate it. And to all our clients out there, we welcome any questions that you may have. If you want to bring a particular question to us, feel free to email either Seth or me, and we'll be happy to respond. Thank you so much.